Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we are starting with another act, that is the Indian Partnership Act 1932. We will be dealing with the important provisions of this act in the form of MCQs. So let's begin. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will include the chapter-wise test, the sectional test and the full-length test. It will be very helpful for your revision. We have also come up with a live crash course for both the phases, phase 1 and phase 2. It includes the live classes. You will be getting more than 60 live classes. It also includes the test series I have just mentioned, and you also get one-on-one mentor support. We are running a limited time period offer, so if anyone wants to avail it, can refer to the link in the description below. Now let's start with the Partnership Act. So the Partnership Act, it came into force in 1932. Earlier, like the Sales of Goods Act, it was also a part of the Indian Contract Act, but in 1932 it was made into a different enactment, right? So in 1932 it was made into a different enactment and it was Indian Partnership Act, right? So the question is, when did the Indian Partnership Act came into force? The answer is, it came into force on 1st October 1932. So the date is 1st October 1932. There are two dates mentioned in section 1. We will be reading it. So that is why this question, it becomes important for your examination, right? So you have to remember this date. So this is 1st October 1932. And what is the other date? Let's read it first. Section 1 provides that Indian Partnership Act 1932 shall come into force on first day of October 1932. So the date is for the act, it is first day, that is 1st October 1932, except section 69. When does section 69 come into force? The section 69, which shall come into force on the 1st October 1933. So this section, it came into force after 1 year, after 1 year of the Partnership Act came into force, right? Why was that? Because section 69 deals with the registration, and this act wanted to give time to the firms to get registered. That is why this section, it came into force in 1933, and rest of the act, it came force in 1932, and the date remains the same. It is 1st October, right? Question number 2. An act of a firm means. So what is included in the act of firm? So the answer is all of these are correct. So we can just move on to the section itself. So what is act of firms, right? The definition here means any act or omission by all of the partners. So any act or any omission by all of the partners is what? It is act of the firm. Or by any partner, or it could be by one partner as well. It could be by all, or it could be by one. Or agent of the firm which gives rise to the right enforceable by or against the firm, which gives right enforceable or by or against the firm, right? So it is considered as what? It is known as the act of firm. So what is act of firm? Means any act or omission by all the partners, or by any one partner or agent of the firm which gives rise to a right enforceable by or against the firm. Question number 3. Which of the following is not an essential requisite for creating a Partnership Act as per section 4 of the Partnership Act? So the answer to this is option C, sharing of losses. They can come up with the contract that they will share losses, but it is, as per section 4, is not an essential element, right? Let's read it first. Partnership is the relation between the persons who have agreed. First and foremost thing at that it is a relationship between the persons. Relationship between the persons means that one person cannot make a partnership firm. It has to be an association of 2 or more persons, right? So it is a relationship between the persons. And what is that relationship? The relationship is of the mutual agency. We will be dealing with it. What is mutual agency? But it is between persons. Persons means that there should be more than 2 persons, right, who have agreed, and they have agreed to do what? To share the profits of a business. So they have agreed to share the profits of the business. For the profits of the business, so there should be a business. It cannot be for charity. It has to be a business. And what is business? This means any trade, occupation or profession. It should be any one of these. Other than this, a business cannot be termed as business as per this act, right? So partnership is the relation between the persons who have agreed, to share the profits of the business, that they have agreed to share the profits of the business carried on by all or any of them acting for all. What is this? This is the concept of mutual agency. There must be mutual agency. Mutual agency means that all are principals and all are agents, right? So what is mutual agency is that for the act of one person, everyone is held liable. Everyone means every partner is held liable. This should be their relationship, right? So by all or any of them acting for all. Now let's read it. Partnership is the relationship between the persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Persons who have entered into a partnership with one another are called individually partners. Individually they are termed as what? They are termed as partners, and collectively they are called what? A firm. And the name under which their business is carried on is called the firm name. So also you should know that a partnership firm, it is not a legal entity. It has not been given a status of a legal entity, right? So a partnership firm and another partnership firm, they cannot form a partnership firm, right? Because they have not been given a legal status. If an artificial person, for example a company, that can form a member, that can form a partner, right? So a person, the natural person and an artificial person, they can form a partnership firm, but two partnership firms cannot form another partnership firms, right? Question number 4. As per section 5 of the Indian Partnership Act, the relationship of the partnership is created by contract, right? We have read it that they must agree. So it is what? It is contract. It is not created by status, right? So the relationship of the partnership arises from contract and not status. Status, for example, that in Hindu joint family, whenever a member is born, he becomes the member of that family, right? So that is by status. But if he has to become a partner in a firm, then they should agree upon that. All the partners should agree upon them. There should be a contract. One partner can only become a partner if they agree upon that, right? So there has to be what? There has to be a contract. So the relation of the partnership arises from a contract and not from status. Which section of the partnership deals with the duty to indemnify for the loss caused by fraud? So the answer is option D, that is section 10. What does section 10 say? Every partner shall indemnify the firm. Every partner shall indemnify what? He will cover for the firm. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of the business of the firm. In the conduct of the business of the firm, if any person has defrauded anyone and loss has occurred to the firm, so who is going to indemnify that? The person who has caused such fraud, right? Let's understand this with an example, right? So A, B, C, they are partners in a firm. So what B does is B defrauds X. Due to this, X does what? X sues the firm, right? X sues A, B, C, all of them. Now the firm is liable for the act of B. That is right. But after this suit, what does B have to do? He has to indemnify the firm. He has to cover the loss, right? He is personally liable for the fraud. So he has to do what? He has to indemnify for the firm. So every partner shall indemnify the firm for any loss caused to it by his fraud. In the case, it will be against all the partners. The case will be against all the partners, but he has to indemnify by his fraud in the conduct of the business of the firm. Question number 6. Which of the sections of the Indian Partnership Act deals with the personal profits made by the partners? So it is section 16. Let's read this section. What does this section 16 say? Subject to the contract between the partners. So this means that it is subject to the contract between the partners. But the general principle is, if a partner derives any profit for himself from any transaction of the firm, if he is personally deriving profit from any transaction of the firm or from the use of the property or business connection of the firm or the firm name, he shall account for the profit and pay it to the firm. So if he is gaining profit personally by the property of the firm or by the business connection or transaction in the firm, then he is liable to do what? He is liable to account for the profit and pay it to the firm, right? So he has to pay it to the firm. For example, ABC, they three are partners and they have have a cake shop in Delhi. A and B, they reside in Delhi, but C lives in Chandigarh, for example, right? So C does what? C prints a card in the name of the business only, in the name of the firm name only, and only provides his number. So now what he does is he is selling cakes in the name of the business, in the name of the company, in the name of the firm, but he is gaining profits personally, right? He is selling the cakes from his house. So this is his personal gain. This is his personal profit. So this is not allowed, and A and B, they are not aware of this fact. So what he has to do, he shall account for the profits and pay it to the firm. He shall, the profits that he has earned from the business name, from the firm name, he shall account them for and he shall pay the firm. If a partner carries on any business on the same nature as competing with the firm, it is also not allowed. So if he is carrying on any business of the same nature or which is competing to the firm, he shall account and pay for the firm all the profits made by that business. So if he is competing with his own firm, right, if he is doing any business, personally doing any business which is in similar nature with that of the firm, then he is what? He has to pay for it. He is liable to pay for it as well. Question number 7. Where no provision is made by the contract between the partners for the duration of their partnership or for the duration or for the determination of their partnership, the partnership is called, then such partnership is termed as partnership at will. So where no provision is made by the contract between the partners for the duration, where no expiry date has been given, or for the determination of their partnership, the partnership is termed as what? Partnership as termed as partnership at will. And it can also happen that they had an expiry date, that they had a duration time, right, and they are still working beyond that duration time. If they are working, then also it is called what? It will be called partnership at will. Question number 8. In case of partnership, which of the following statement is not true? Partnership is not a legal entity. Two partnership firms can form a partnership firm. Two companies can form a partnership firm. This I have discussed with you. The answer is option B. Two partnership firm cannot form a partnership, right? So two firms cannot make another partnership firm. So partnership is not a legal entity, this I have told you, but it is a group of persons associated for a specific object. Two partnership firms cannot form a partnership firm. Two companies can form a partnership firm. This we have already discussed when we were dealing with section number 4. Question number 9. Section 35 of the Indian Partnership Act deals with, so it deals with liability of the estate of a deceased partner. Very simple section, let's just read it. So where under a contract between the partners, the firm is not dissolved by the death of the partner, if it is still continuing, the estate of the deceased partner is not liable for any act of the firm done after his death. Then his estate is not liable after his death for any act that they are doing in that firm after his death, right, after the date of his death. Very easy. Where under a contract between the partners, the firm is not dissolved by the death of the partner, the estate of the deceased partner is not liable for any act of the firm done after his death. Question number 10. Dissolution on happening of a certain contingency, it is provided in section 42. Let's read the section. Subject to the contract between the partners in a firm, if the firm is dissolved, if constituted for a fixed term by the expiry of that term. For if it was constituted for a fixed term, on expiry of that term, what will happen? It will be dissolved. And in case it does not dissolve and the partners are still working, it is called what? It is called partnership at will. Next, if constituted to carry out one or more adventures or undertaking by the completion thereof. So if the purpose is met with, then also by the death of a partner. So it can also be dissolved by death of the partner or by the adjudication of a partner as an insolvent. But all these conditions, they are subject to the contract between the parties. So that means that so they can contract contrary to these provisions as well. Next question. Section 25 of the Indian Partnership Act provides liability of a partner for the acts of the firm. So every partner is liable jointly with all the other partners and also severally for all the acts of the firm done while he is a partner. So while he is a partner, he is liable personally also and jointly also, and so he is personally liable also and he is jointly also liable. So this is the concept of mutual agency. Question number 13. Which section of the Indian Partnership Act deals with the right to restrain from the use of firm name or firm property? The answer is option C, that is section 53. Let's understand this section. What does section 53 say? After a firm is dissolved, every partner or his representative may, in the absence of a contract between the partners to the contrary, restrain any other partner or his representative from carrying on a similar business in the firm name. So they can make such provisions, right? So they can carrying on a similar business in the firm name, or from using any of the property of the firm for his own benefit, or they can also restrain him from using any of the property of the firm for his own benefit until the affairs of the firms have been completely wound up. Until and unless they have completely wound up, they can make such restraints, right? Provided that where any partner or his representative has bought the goodwill. So in case they have bought the goodwill, nothing in this section shall affect his rights to use the firm name. In that case, he can use the firm name if they have bought the goodwill, but in others they can restrain it, right? And wherever the term the legal representatives is coming, in that case what happened is, it means that the partner has died. So one of the partners has died, and now the question is arising with relation to who? The legal representatives, right? The legal representative does not become a partner by status. This we have read. He does not become a partner, right? So he can only become a partner by agreement. Here, why he is coming into the picture? Only because of his share, because the share of the deceased person, right? Question number 14. Whether a notice given to a partner who habitually acts in the business of the firm of any matter relating to the affairs of the firm will be deemed to notice to the firm? The answer is yes. The answer is yes. It operates as a notice to the firm except in the case for a fraud on the firm committed by or with the consent of the other partners. Let's read this section. Notice to a partner who habitually acts in the business of the firm. So he who habitually works, that means he is an active partner. He is not a sleeping partner, right? He is an active partner of any matter relating to the affairs of the firm. Any matters relating to the affairs of the firms operates as a notice to the firm. So if the notice has been given to an active partner, it is deemed that the notice has been given to the firm, except in the case of fraud on the firm committed by or with the consent of the partner. But in case of fraud, this is not going to be a valid notice. Let's understand this with an example, right? So A, B, C, they are the active partners, and D is a sleeping partner. X wants to sue them, so X gives them a notice that if you don't pay me my share of money, I will sue you in 30 days. So if he is giving his notice to D, the sleeping partner, it is not going to be a valid notice. But if he is giving his notice to A, B or C, then it is valid. Now for example, X defrauds the firm and with the consent of B. What happens is, for example, B calls X that okay, you send me the notice and you pay me 10,000 rupees. I will not tell A and C about the notice, right? And then you can do what? You can sue us. So this is what? This is not going to be a valid notice, because here the B has frauded. B is defrauding the firm, right? So X is also defrauding. Because of the fraud committed by X and B, it is not going to be a valid notice. Now let's read it. Notice to a partner who habitually acts in the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm except in the case of fraud on the firm committed by or with the consent of the partner. So if the partner is committing that fraud, or it is being committed with his consent, so then it will not be deemed as a valid notice. Question number 15. In which of the following conditions a person may be deemed as a partner by estoppel or holding out? The answer is all of the above. When he, by his conduct, represents himself to be a partner in a firm, when knowingly permits himself to be representing to be a partner in a firm, when he expressly by words spoken or written let the others that he is a partner in the firm. So answer is option E. Section 28 is really important and it is very easy at the same time. Let's just read it. It is based on the principle of estoppel, right? So anyone who by words spoken or written or by the conduct represents himself. So this is what? This is estoppel. If he represents himself either expressly or impliedly, then or knowingly permits himself to be represented, this is holding out. If he is permitting someone else to represent him, to be a partner of the firm. Either he is doing it himself or he is permitting someone that okay, you represent me as the partner, is liable as the partner in the firm to anyone who has on the faith of such representation. If someone on the faith of such representation given credit to the firm, if he is giving credit on the faith of such representation, then what? Then he cannot deny it later on that I was not a partner, right? Whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so giving credit, whether he knows that it has reached the person's giving credit or not, it does not matter. But if he is permitting, if he is representing himself or if he is permitting someone else to represent himself as a partner, then what? Then he is liable as a partner only. This is the concept of holding out. This is the concept of estoppel. Let's take an example. For example, A, B and C, they are partners. D is a servant in their partnership firm. But D has a friend who is very rich. So A, B and C, they ask D that you please call your friend. Let's say that friend is X. You call your friend, we want to have a meeting with them, right? So now all of them, they are having a meeting. So A says in front of D that D is our partner. He says this to who? He says this to X that D is our partner, and D keeps silence. He does not say anything. He should have done what? He should have contradicted it, but he says nothing. So here, if X pays something to the firm, if he gives any credit to the firm, and if in case of any loss happens to the X, so what will happen? Then D also will be deemed to be a partner. He cannot say that I was not a partner, or he cannot say that I was not clear, I did not know that this representation had reached X, so he cannot deny now. Once he has represented, and on such representation if someone has given credit, now D in this case, he cannot deny it, right? So he will also be deemed partner, that is, he also be made liable as much as A, B and C, right? Where after a partner's death, the business is continued in the old firm name, the continued use of that firm or the deceased partner's name as part thereof shall not itself make his legal representative or his estate liable for any act of the firm done after his death. Clear what is holding out? Now question for achievers. The dissolution of a firm means, it means the dissolution of the partnership between all the partners of the firm. It means the change in the relationship of the partners, or it means the reconstruction of the firm. So you have to comment the right answer below. So that was all for today. I hope it was an helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.